With the consent of the other side, my lord. Well,
Yes, what is the prayer? You are seeking adjournment.
yes,
My lord, the date may be fixed after vacation 14th July. My lord,
14 July may not be.
my lord, then
last week of July.
no, my lord, it's already
Then
Oh,
16, my lord. 16
Don't
July.
fight amongst yourself. Let the court master give the date.
March.
Heard Mr. S.K. Ghosh, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr.
A.K. Hannan,
A.K. Hannan, who does not oppose the prayer but prays for giving a fixed date for hearing. The prayer is allowed. Let this matter be listed 11th August.
March.
My lord, I beg,
August is too late, my lord. Already we are not allowed to give the consent, but last week of second week, third week.
We are giving dates as per the available space in our court diary. 11th of August. Yes.
my lord, I beg to mention item number 11, my lord. So today, my lord, we have some difficulties, my lord. Let be any other day, my lord.
Who are you?
My lord, I am for the appellant, my lord.
Have you informed the other side?
Yes, he is the other
I am
side.
appearing for the response.
Heard, Mr. What is your name?
K. Uddin, my lord.
K. Uddin, learned counsel for the appellant, who prays for an adjournment. Mr. H. A.K. Hannan, learned counsel for the respondent, does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed 11th of August.
May I please, your lordship, with the consent of the other side, I beg to mention item number 8, your lordship. Kindly adjourn the matter for the day, your lordship.
Why?
Because my senior is due to some medical emergencies, he is
Who is for the other side?
The matter may be fixed next week, lordship.
Next week is not possible.
Then before vacation, any date.
after vacation.
Before
Because it is a
vacation
very
day,
old matter, lordship, 2015 matter.
before vacation dates are not given.
Vacation, your-
Heard Mrs. Paul, learned counsel for respondent number 1. Also heard Mr. D. Chaudhary. What is your name?
R.K. Sharma on behalf of D. Chaudhary.
R.K. Sharma, learned counsel for the appellant, who prays for giving a fixed date of hearing. The prayer is allowed. Let this matter be listed 11th of August.
May I please, your lordship? For listing of RSA for orders, lordship. Can it be on Monday, lordship? For orders matter, lordship.
17th.
7th of lordship.
May I please, your lordship, I beg to mention RSA case number 52 of 2016 for withdrawal. Can it be fixed on Friday,
Okay. Okay.
tomorrow?
Tomorrow, okay.
Much obliged.
May I please, your lordship? Also, I beg to mention item number 9. Learned counsel is out of station, lordship. So a date may be fixed. You have taken consent from the
Yeah.
others.
Heard
9.
Mr. D. Majumdar, learned counsel for the
Appellants.
appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is out of station. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed 13th of August.
Much obliged.
May I please, sir? Your lordship, I beg to mention one CRP IO against the order of the learned civil judge who Kabul Petro. And that may be listed tomorrow, your lordship, as on 15th is being fixed for argument. That is,
When have you filed?
is today itself, your lordship. Because 2 days before the order has been passed.
When the order was passed?
2 days. before.
Okay.
May I please, lordship? Lordship, I beg to mention item number 7, Lordship. I am for the appellant, Lordship. I have taken consent from other side, Lordship. May I taken after vacation, Lordship.
What is your prayer?
Lordship, may I'm praying for adjournment, Lordship. I am for the appellant. Have
Heard
taken
Mr.
and Hawk, Lordship.
N. Hawk, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty.
Lordship.
He submits that he has informed learned counsel for the respondent side regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed 13th of August.
Obliged, Lordship.
Yes, Lordship, I beg to mention item number 14. Which are the concept of authorization.
What is your prayer?
Lordship, may kindly adjust the matter for the first week of August or
Today
immediately
was,
after.
what is your name?
B. Hazarika.
For?
Respondent number 1 and 2.
Heard Mr. B. Hajorika, learned counsel for respondent number 1 and 2, who prays for an adjournment. Also heard Ms. R. Kakoti, learned counsel for the appellant, who does not oppose the prayer. Hence same is allowed. Let this matter be listed in the second week of August on a date to be fixed. Date 18th of August.
May it please your Lordship. I beg to mention item number 5. Lordship, in this matter, for the purpose of amicable settlement, this is discussion is going on between the parties, your Lordship. We have missed some more time, your Lordship.
You have informed the other side regarding. Okay. Heard, Mr. What is your name?
R. Ali on behalf of MS.
R. Ali, appearing on behalf of Mr. M. H. Ahmed. Also heard Mr. A. Hussain, learned counsel for the respondent side. It is submitted at bar that some discussion is going on between the parties to reach an amicable settlement, and there is a hope of reaching an amicable settlement. However, some time may be required for the same. Hence, the prayer for adjournment is made. The prayer is allowed. Let this matter be listed in the second week of August on a date to be fixed by registry.
Much please. Wait, please, your Lordship. Lordship, praying for listing of an IA in civil division petition. For motion.
For motion,
For amendment of the post title.
next week, 17th,
15 Monday.
Monday difficult, 17th.
Obliged.
Hey, please, your Lordship. Lordship, I beg to mention for listing of one CRP, Lordship. CRP is in the stage of hearing and it is arising out of eviction suit. CRP is of the year 2017, Lordship. Lordship, but short date may be given.
Hearing listing, not by mentioning.
Lordship. On last date, the matter was supposed to be listed after 2 weeks, Lordship.
Hearing will go in the month of August only. Give a date. 18th of August.
Obliged.
Give mention memo.
May please your Lordship. Scenario is on leg. Can it be taken after some time, your Lordship?
Okay.
May I please, Madam?
Yes.
But this matter relates to injunction, my lord. Petitioner before a lordship is the defendant. My lord, matter relates to, my lord, under the Trademark Act, my lord. The allegation, the case of the plaintiff is that, my lord, what happened, there are two, this country liquor shop, country liquor, my lord. So there are two brands, my lord. One name is Raghi and another name is, my lord, Rhino number 1 and Rhino, my lord. So since the, my lord, labels, the label that the dress code is used in the bottles are similar, so therefore they have filed the suit. Saying that, my lord, since this is similar, so this is a passing of the label used by the plaintiff since 2017. And although the defendant is in business since 2018, but since 2024-25, he has changed the label, which is similar, my lord. So by that, my lord, he is passing off his label, and due to that, he is suffering loss, my lord. So along with that, my lord, he has filed one application for injunction, my lord. The trial court has granted injunction by restraining that the labels shall not be used, as well as the stock in trade are also, my lord, restrained. And along with that,
After hearing both the sides.
yes, my lord.
Finally, temporary
Yes, sir.
miscase has been disposed of.
Disposed of, my lord.
Okay.
So, but along with that, my lord, all the assets of the firm is also, my lord, attached, my lord. Against that, my lord, appeal preferred, my lord. Appeal also dismissed, my lord. So after that, this revision I have filed, since this is under the Commercial Court Act, my lord. So under 115 CPC is not maintainable. That's why earlier I have filed under 115 that I have withdrawn with liberty, my lord. Now I have filed under Article 227, my lord. So, my lord, may I pray one thing, my lord, since my friend is appearing for the caveator, my lord. So, and I'm not praying any stay at this stage. So, lordship may fix a date for admission, and on that date can be disposed of. My lord. Records perhaps may not be required, my lord, subject
There are
to.
some preliminary issues that has to be heard before the court can go into the facts or grounds raised.
Like,
The preliminary issues are with regard to whether under Article 227, this honorable court can invoke its supervisory jurisdiction and rehear the entire case. What they are praying for, your lordship, even if your lordship can go through the grounds, they want a rehearing of the entire case on facts as well as on law, your lordship. Under Article 227, this is a supervisory jurisdiction, your lordship.
yes, this plea you can take while objecting to
Yes, your
their plea.
lordship. That's right. Your lordship.
So we'll fix a date
Your lordship.
for admission hearing.
Your lordship.
Heard Mr. A.K. Gupta, learned counsel for the petitioner. Also heard Mr. What is your name?
N. Datta, your lordship.
N. Datta, learned counsel for the caveator / respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 12/2/2026 passed by the Court of London Additional District Judge Jorhat in Miss within bracket A case number 9/2025, whereby the order dated 12/11/2025 passed by the commercial court. Which court passed the order?
Additional District Judge of Jorhat.
No, the original order.
Additional District Judge.
Or the additional district judge passed the
No, my lord, as a civil judge, senior division, Jorhat.
Sorry.
Civil judge, senior.
passed by the Court of London Civil Judge Senior Division
Jorhat.
Jorhat in Miss J case number 146/2025, arising out of commercial suit number 11/2025, whereby the respondent was granted temporary injunction by the trial court and same was affirmed by the appellate court. Stop. Since Mr. Dotto has appeared for the sole respondent, no necessity of issuing formal notice is there. You have received the copies.
Yes, sir.
Stop. This matter may be listed for admission hearing on
Vacation, your lordship.
24th July. List accordingly.
Like,
No, one line. It is submitted at bar that the requisition of trial court records may not be necessary at this stage, considering the annexures which are annexed, considering the fact that relevant annex documents are annexed along with the instant revision petition, list accordingly.
Obviously.
May I please, your lordship?
Yes.
Your lordship, service has awaited your lordship.
Lordship, I am appearing for all the respondents. We have filed our caveat, Lordship. We have acknowledgement, but somehow the copy did not serve to us and we did not know about the matter.
Okay.
Lordship, we have
You
to,
have filed Wakalatnama.
Lordship, we will file. I'll have to take instruction, Lordship, whether we have filed or not.
Third Miss, what is your name?
Miss P. Day on behalf of Mr. S.P. Roy.
Third Miss P. Day, Learned Counsel appearing on behalf of Mr. S.P. Roy, Learned Counsel for the appellant. Also Miss
K. Bora, Lordship.
K. Bora, who submits that she has been instructed to appear on behalf of all the respondents. However, she submits that she has not received copy of memo of appeal as well as annexures annexed thereto. The appellant is directed to furnish the copies of requisite numbers of copies of memo of appeal as well as annexures to the learned counsel for the respondents. On perusal of the office note dated 9/6/2026, it appears that records of the trial court as well as first appellate have not yet been received. Registry to issue reminder for the same. Let this matter be listed again on 24th July.
Small prayer, earlier did Lordship for this, before vacation if possible.
Not possible.
Your lordship, there is an interim order which shall be extended.
Where is the interim order? ISM. In IA also show her presence. You'll be filing any objection?
Yes.
IA Duta naam likhi. Learned counsel for the opposite parties raised for some time for filing written objection against the interlocutory application filed by the applicants. Prayer is allowed. Let this matter be listed 24 July. The interim order shall continue till next day.
Of next.
Sorry for interference. In item 11, if I may fix this on 13th of August, madam. Because I have taken consent from the appellant.
Item number 11,
13.
instead of 11 August, it should be 13th August.
The procedure is on night. Can it be taken after something?
Let me start.
No, no. Let him come. Who will be coming?
Senior counsel, Mr. B. Dutta.
Who does it?
The first applicant. I saw my matter to service.
Okay.
We'll take it up after something.
Hearing, item 6.
Item 4,
My lord, I am for the petitioner.
Miss
But
Chakravarti. Your matter is listed at 2. Item number, you are for item number 2, 4. It will be taken up at 2. Cause list shows the time. Yes, Mr. Bhatti.
My lord, the other side is not here. Let it come on Tuesday, my lord, in that case.
Who is appearing for?
ED Deka. Let it come on Tuesday, my lord.
Putul. Tuesday, possible আছে? It will have to go after vacation.
Let it be so. In that case, my lord, let it be listed in first week of August. I
Oh.
could be out of station
Okay.
in the month of July.
Okay. Third, Mr. O.P. Bhatti, Learned Counsel for the appellant. No one has appeared for the respondent side. Hence, let this matter be listed on
On sixth, let it be on
the
sixth
6th of August.
6th August. Much of it.
Who is for the other side?
Other side, my lord. Partition case actually it was, you know, service complete, possibly.
What case? Partition. Where is the service of?
Yes, no, their name not shown, my lord. Service complete. Service complete. Office not 10/5/22.
Thereafter, whether any order has been passed.
Last it was, my lord, 9/9/22. Last, so no. That's Rahane niki. Exam is it? Maybe at all. Okay. Oh, it is. 16/9 admitted, so. Hospital fees. 16/9. The service to be also.
There is no order,
That's it?
no order holding the that the service has been duly, the notice has been duly.
But it is 10/5/22.
No, it is there.
Yes. In my note, I have seen.
Who is Nomita Das?
Nomita Dam. She sister, my lord. She prayed for partition. Dispute is that, my lord, I also filed in one petition, my lord, before this honorable court, that she cannot, she may not sell her plot, part of land, my lord, to other, my lord. In this connection, she may be allowed, she may stay along with us. She prayed for partition of a joint property. Others not consented, my lord. And one plot of land given to the, my lord, elder brother. So, my lord, it was, land will be per head 1.125 lesser only. So, but she has sold it to solely to different religious person. We objected her, you may stay here and also take the value of the land, but you cannot sell it. because otherwise we have also Mondir also, and all brothers sisters are residing there. We have no objection. That is why you have in affidavit filed one affidavit, my lord, 11/2/2020, saying that and for requesting her to take the money also and stay also, but not to sell her plot of land, my lord, part of land. In the meantime, it was my lord state, my lord. We have no objection if she stays along with us for her part of land. It was 11/2/2020 filed.
No, what is the substantial question?
In page 6, my lord, according to me, whether the learned trial court as well as the first appellate court are correct to decree the partition of the suit land having dwelling house and no vacant place in that suit land. Whether the corrected schedule of the land of the suit land measuring 2 kata 17 lesas can be partitioned among all the brothers and sisters of the appellant and the respondent, which is practically a very small 6 lesas of land. Therefore, the said share of the suit land may not be.
The substantial questions of law were formulated on 16/9.
Yes, my lord.
Only two substantial questions.
Whether preliminary decree under section 2, subsection 2 of the Code of Civil CPC is executable without the final decree being based on the report of the Deputy Commissioner with possession as directed by the learned trial court. Whether properties of the parental ancestors can be sold without the consent of the successors.
Yes, only these two questions are in the
Respondent not present, none appears for the respondent, it was there. Second line of the order. 16 line.
No, but before that,
Lordship.
there has to be a judicial order regarding due service.
Oh, yes.
There is no.
Then I may take step again, my lord, if your lordship direct me.
She's your sister.
No, she has not appeared earlier.
No, otherwise where she is residing?
Residing there near where her address is mentioned here. There is no issue that.
Then you also serve notice through Dusty Mo.
Yes, Dusty mode. That will be better. Only Dusty mode.
He will be knowing.
Yes, yes. Only Dusty mode.
Okay, heard Mr. H. Das, learned counsel for the appellants. It appears on perusal of the case record that no order regarding due service of notice on the sole respondent has been made by this court, though office note dated 10/2/2022 shows that the notice issued to the sole respondent that shows that the AD card sent along with the notice issued to sole respondent has returned back with signatures of one Nomita Dam thereon. Who is the respondent number? Who is the sole respondent in this case? However, stop. Learned counsel for the appellant submits that the respondent is the sister of the present appellants and hence considering the fact that the office note that the relevant office note regarding due service of notice is an old office note of the year 2022. The appellant is directed to take fresh steps for service of notice upon the sole respondent by Dusty mode. In the event the appellant is able to serve the notice by Dusty mode, they shall submit an affidavit of in compliance thereto before this court on the next date fixed. These steps shall be taken within 15 days from the date of this order. Let this case be listed again on 29 July.
Oh, like.
Also, in this case, I'm led by Mr. Kane, shot. He's on legs in court 18, just timing for the timing.
Okay. Okay.
I presume looking at the list, everything is adjourned. He just on legs in court 18. I just came from.
Okay. Item number 8, item number 2.
Item.
If, because my other side friend is also busy. Well, because some other cases are there.
It can be started, your lordship. I'll be there. I'll take notes. His order has been passing the your lordship court number 15, so he'll come in 5 minutes.
I can start, well, there is no problem.
Okay, you start. The appeal is not yet admitted.
Because, my lord, there was a order passed by this court on 24/1/2020, when it was sent back for taking additional evidence. 24/1/2020 by this Honorable Gauhati High Court.
Okay.
Thereafter, it has came back. Now it is for admission.
No, before sending back,
It was not admitted. It was only order was passed for under Order 41, my lord. Rule 27 for additional evidence. It was kept pending and it was sent for taking additional evidence. The matter was kept pending, my lord. 24/1/2020.
yes,
May I start, my lord?
yes.
My
Well,
lord, this is a defendant's appeal before your lordship.
you were the defendant before.
For a defendant in the suit. Basically, my lord, at page 3.
Yes.
Page 3, my lord, the substantial questions of law are laid down.
Yes.
My lord, the plain prayer portion is at page 11 by the plaintiff.
Suit was for
Right
declaration,
title, interest, position, and
Declare-
confirmation of position.
confirmation or
two,
recovery of cash position.
recover, delivery of cash position. Both are there. Confirmation of position and delivery of cash position.
How both reliefs can be
Well,
there.
that. These two prayers were there. Malad, now, before going to the appellate court judgment, Malad, I kindly consider your lordship to look into the title suit judgment, which starts at page 18. Plaintiff case and defendant case is written down there, Malad. Page 19, may I read, Malad?
Yes. Yes.
The plaintiff is the owner. Plaintiff case your lordship has got. The
Yes.
plaintiff is the owner of a plot of land measuring 2 kata, 11 leases covered by periodic patta such and such, village Shohor Patashil, Moja Beltola, out of that in terms of LA case number such and such of Gauhati. When an area of 14 leases were acquired by the state, the plaintiff is having confirmed ownership and possession over the land measuring 1 kata, hereinafter referred to as a suit land. Although the revenue record shows an area of 8.64 are in the name of plaintiff, plaintiff due to her old age used to manage the aforesaid land through her agents and servants. That on 8/2/2000, the plaintiff found that even if she had not relinquished her right over the suit land in nobody's favor, including the defendants, the defendant number 2 had mutilated his name in respect of the suit land in terms of order passed in mutation case number such and such, instituted before circle officer.
Who is defendant number 2?
Defendant number 2, Malan. I am defendant number 1. Defendant number 2 has filed a written statement, but he has not come for evidence.
No, what
From
is
whom?
your relation? Is there any relationship?
Malan, from defendant number 2, I have purchased through registered sale deed.
And defendant number
Defendant number 2 has purchased from the grandfather of the plaintiff.
Okay.
Basic question is this, my lord. The plaintiff, your lordship, has seen the prayers.
Okay,
in the
no,
plaintiff.
read the facts.
Respect of the orders in mutation case, the plaintiff immediately applied for setting aside of the mutation order 9/2/2000 before the deputy commissioner and also preferred appeal before the deputy commissioner. According to the plaintiff, during pendency of the appeal in November 2000, the defendant number 1 began construction of concrete structure over the suit land. The plaintiff came to know that the defendant number 2, through the impugned mutation order, managed to carve out a special patta and dag within the patta of the plaintiff land of patta number 44 of Shaw, which was numbered as patta number 105, dag number 740. The new dag and patta number, a part and parcel of 2 kata 11 letters of land, belongs to the plaintiff, is the actual suit land in question. The same is admittedly in possession of the defendants, where construction of the permanent structure is on. Claiming mutation done, the defendant number 2 as fraudulent as per mutation number such and such, the plaintiff accordingly prays for following relief. Though the relief of the plaintiff is written down. Now the defendant's version, Malad. I am appearing for defendant number 1. Malad, your lordship may look into the first page. Malad, defendant number 2 is Pradeep Kumar Chandra Sharma, and defendant number 1 is Onju Medhi, and the legal heirs that they have now before your lordship. My lord, the defendant number 1 in his written statement contended as per the land record that one Sri Gunovi Ram Sharma, the grandfather of the present defendant number 2, purchased the suit land measuring 1 kata with position number such and such Fatashil under Beltola Moja White registered sale deed number such and such dated 27/12/1955. So that is the grandfather who has purchased this land. After Gunovi Ram, his son Mahesh Sharma inherited the 1 kata of land, was residing there by constructing a Assam type house in the year 1965, bearing holding number such Ward number 11 of Gauhati Municipal Corporation. After Mahesh Sharma, his son Pradeep Sharma, that is defendant number 2, inherited the land measuring 1 kata. According to defendant number 1, meanwhile the dag and patta has been changed to 260 and 44 respectively. The CM was mutated in the name of defendant number 2 on the basis of inheritance by mutation case number such and such, and in respect of 1 kata of land of dag number 260 and patta number 4, Shahar Fatashil, part 1. Defendant number 2 was granted perfect partition by the order dated such and such, PP case number such and such, was consequently given a separate new patta 105 with dag number 740. Thereof the said land, along with houses standing thereon, was sold by defendant number 1 to defendant number 1 by registered sale deed such and such, dated such and such. So defendant number 2 by registered sale deed sold it to me, and the grandfather of defendant number 2 purchased from them. Claiming himself to be a bona fide purchaser for value under defendant number 2, the defendant number 1 claims dismissal of the suit. Similarly, denying the right of the plaintiff over the suit land, the defendant number 2 submitted that the plaintiff is out of possession of the suit land since the year 1955, and defendant number 2 and his predecessor in interest, who was in actual possession of the suit land since 1955, have been enjoying the right over the same openly and adversely to the plaintiff. According to the defendants, the mutation order such and such, by which his name was mutated in respect of the suit land, having been not challenged by the nobody within stipulated 5, same has reached the status of finality and winding upon 1. The defendant number 2 admitted the fact of transferring his right over the suit land to defendant number 1, that is to me, and while registered sale deed such and such, and also admitted the delivery of possession of the same to the latter. So defendant number 1, from there in 2000 I purchased through a registered sale deed, and in 1955 the defendant number 2 purchased by a registered sale deed. Your Lordship, till now, my Lord, this is the fact.
No, if the grandfather has purchased
My Lord,
it,
55.
then why they are claiming
Who is claiming?
the right of adverse possession?
My Lord, defendant number 2, he is saying that he is claiming, but defendant number 2 is not before your Lordship. I am defendant number 1. But I have purchased by a registered deed in 2000 from defendant number 2. Defendant number 2 has only filed a written statement and has not appeared before the court in evidence. But there is the registered sale deed is never under challenge. And I am in position, that is an admission, and I have through that sale deed, I am in position, but till now, my instruction goes, getting the opportunity also, this sale deed was never under challenge.
Your sale deed.
My sale deed was never under challenge.
And the grandfather's.
That is also not under challenge.
But that is on record.
That is on record.
Okay.
Because the defendants, because the evidence was not there from defendant number 2. So that was only in the written statement was there. Your Lordship will find that document that was exhibited by the defendant at page 31.
Okay, then what happened?
My document sale deed original was exhibited. That is at page 31. Your Lordship will find.
No, whether defendant number 2 has inherited the suit land
through the mutation, my Lord, it was inherited
from his grandfather,
my Lord.
Or he's claiming on the basis of adverse possession.
My Lord, that can only be said by the defendant number 2.
But he did not adduce any
evidence. He did not. He didn't adduce any evidence. That is an admitted fact.
Okay.
My only thing is this, my Lord. I have purchased by a registered sale deed, which is not never under challenge.
Okay.
Whether under section 34, which was also argued before the trial suit, that was not discussed by the appellate court. Under 34, whether the suit is maintainable. I will place all the decision, it is not maintainable under specific relief.
Okay, thereafter what happened?
My Lord, just Your Lordship, my Lord, some problem in the eyes. Issues of the suit are there, my Lord. The first issue is whether the suit is maintainable in law as well as in facts. Barred by limitation. Suit is barred by 154 of the Land and Revenue Regulation. 4 is important, whether the plaintiff has right title interest over the suit land. 5 and other reliefs. My Lord, I will take your Lordship directly to issue number 4. That is at page 23.
Yes.
The plaintiff claiming her right title interest over the suit land measuring 1 kata, covered by patta number such and such, now covered by dag number such and such. In order to prove his right over the same, see Hiranya Kumar Chaudhary, the power of attorney holder of the Dick's plaintiff, who later became plaintiff as substituted legal heir of original plaintiff, Profulla Moi Chaudhary, has adduced evidence as PW land. Following documents were exhibit in the said witness. Deed of power of attorney, certified copy of Jamabandi, patta issued by the plaintiff bearing patta number such and such. Memo issued under 9(2) of the Land and Acquisition Act. 5(6) is revenue paying receipt. Certified copy of Jamabandi, remarks of mutation, certified copy of such and such, certified copy of the revenue appeal, certified copy of the separate patta number, separate of status quo order passed by the Civil Judge Junior Division, copy of the disposal of debtors such and such. Next page, Manat. The PW1 in his evidence has deposed that the plaintiff was the owner and title holder in respect of plot of land measuring 3 kata 5 lachas, comprised in dag number 145 of KP Patta number 21 of village Notun Town, Fatashil of Moja Beltola. The said land during last resettlement operation was converted to dag number 260 and Patta number 44. The plaintiff vide exhibit 2, the copy of Jamabandi, issued on 1986, has shown the name of plaintiff appears to be the only recorded pattada in respect of the land pertaining to an area of 8.70 R in dag number 145 and patta number 21 till the year 1986. Defendant though put suggestion to plaintiff that dag number 185, it will not be 185, it will be 145, my lord, this typing. 145, patta number 21 is not the same. That with that of dag number 260 and patta number 44. But PW1 denied the same, and defendant has failed to prove contrary to it by adducing any evidence. Exhibit 3, issued in the year 1987, also verifies that in respect of land pertaining to dag number 260 and patta number 44, the plaintiff is the recorded pattada. From the land revenue paying receipt in form of Exhibit 567, it also transpires that land revenue receipt issued in 1986 and 2003, plaintiff has been paying revenue on behalf of herself in respect of patta number 44. Whereas copy of Jamabandi, that is Exhibit 8, as produced by plaintiff, which is compared with the original. And this will not be C, Mallet, and exhibit, it will be G. G is it will be Mallet defendant's document, what I find. G will be the original sale deed. And exhibit G of defendant as compared with the certified copy issued in 2000, which shows just after the name of plaintiff, Profulla Moi Chaudhary, as pattada of the land of such and such, name of defendant number 2 appears as pattada. That exhibit C, my lord, your lordship may turn to page 31. Your lordship will find defendant's documents, page 31. Defendant's documents 7, serial number 7, exhibit G, original sale deed of such and such 2000. That will be G. However, then my lord, shows the name, just the name below the plaintiff profile as pattadar of the said land. So my name was there as a pattadar of the said land. However, interestingly, but Exhibit 8.1, the comment engrossed in the said document, it appears the name of Pradeep Sharma, the defendant number 2, came as the pattadar of that land on the basis of sale and also by way of inheritance as per order of mutation case number such and such. Whereas the plaintiff has clearly denied the fact that neither she had sold any land pertaining to dag and patta to defendant number 2, not defendant number 2 in any way a year of plaintiff to inherit his property by of inheritance. So under the present circumstances of the suit, the onus of proof under section 101 of the Indian Evidence Act shifts to the defendant. Only by denying mal can the onus will shift to the defendant here. Because the court itself says the patta, my name is there after the plaintiff. And the sale deed was never challenged. To prove that their names have been validly mutated in respect of the suit land after the plaintiff Prafullo Moichudari and how they have acquired the right over the suit land. Defendant number 1 claims that he is the bona fide purchaser for value in respect of the suit land as he is on the basis of sale deed bearing number such and such has purchased the land from defendant number 2. As such, he has a valid right over the suit land. The defendant number 1 also claims the suit land.
Just a minute. Yes.
That the again, what I read from earlier. Defendant number 1 claims that he is the bona fide purchaser for value in respect of the suit land, and he is on the basis of sale deed bearing such and such has purchased the land from defendant number 2. As such, he has every valid right over the suit land. The defendant number 1 also claims that the suit land was in continuous possession of defendant number 2 since 1955 by constructing houses thereon. According to him, he purchased the land from Pradeep Sharma, that is defendant number 2, who in turn was in possession of the same being inherited from Mahesh Sharma, and that Mahesh Sharma has inherited the same from his predecessor in interest, Sri Gunohi Ram Sharma. So to prove the title over the suit land, the defendant number 1 has to show that his vendor, defendant number 2, has a better title than the plaintiff over the suit land. Accordingly, in an attempt to prove his assertion, the defendant number 1 exhibited the following documents. Here, your lordship will find my original sale deed is also there. After analyzing the exhibits of defendant number 1, it appears that the defendant number 1 has produced before the court the sale deed executed by the defendant number 2 as exhibit G in respect of the suit land. But the claim as to the chain of title over the land as claimed by the defendant number 1, the defendant number 2 has inherited the same from his predecessor in interest, Gunohi Ram Sharma and Mahesh Sharma, has not been proved by defendant number 1. Even though it has been claimed that the suit land belongs to the predecessor interest of defendant number 2 from 55, but exhibit 3 shows that till 1987, name of the plaintiff was on the record of rights as only recorded Pattada. And thereafter in 2000, abruptly, name of defendant number 2, Pradeep Sharma, came to be the Pattada of the same. But no chain of title has been shown and proved as claimed by defendant number 2 has inherited the suit land from the predecessor in interest C. Mahesh Sharma, who in turn has to go that from Gunohi Ram Sharma. It is also interesting, as claimed by the learned counsel for the plaintiff, that the defendants, though claimed that the original purchaser of land, that is predecessor in interest, purchased the land in 1955 by Exhibit Z, which was inherited later by defendant number 2, Sri Pradeep Sharma. But till 1987, only name of plaintiff appears to be the only Pattada, and the name of Pradeep Sharma appears as Pattada in Exhibit C of the defendant, and Exhibit 8 of plaintiff on the basis of sale as well as inheritance, just of the name of plaintiff. As the defendant number 1 claimed that suit land transferred inter vires and vested upon defendant number 2. So names of predecessor interest of defendant number 2, that is Gunohi Ram Sharma and thereof Mahesh Sharma, must have to be available in the record of rights prior to his name as recorded Pattada. But no chain of title appears to me in the record of right, that is Exhibit A. No document has been produced by the defendant number 1 also to show the chain of title over the suit land by which he acquired the very title over the same, even though he claimed to have verified the chain of title vested upon the vendor, that is defendant number 2. On the other hand, defendant number 1, under whom the defendant number 1 is claiming his title, has made the same as defendant number 1 through his written statement. He has acquired title over the suit from his predecessor interest Mahesh Sharma, who in turn has acquired the same from predecessor Gunohi Ram Sharma. However, the defendant number 2, after filing a written statement, never contested the suit. Learned counsel for the plaintiff argued that as defendant number 2 has never come before the court to substantiate his claim, so the assertion raised by him are to be presumed as incorrect. In this regard, I would like to place reliance upon the decision of Apex Court, such and such. where a party to the suit does not appear in the witness box and state his own case on oath, does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. In the present suit, in his pleadings of defendant number 2, assert that he and his predecessor interest was in actual possession of the suit land adversely and openly to the plaintiff since 1955, and in open assertion to the knowledge of the plaintiff. According to defendant number 2, claims that the suit of the plaintiff is barred under law of adverse possession. Thus, in my opinion, burden of proof such assertion lies on the defendant number 2. But as he fails to do so, presumption can be drawn under section 114 of the Indian Evidence Act. The defendant failed to prove his claim. On the other hand, it is also pertinent to mention here that as per the settled law relating to adverse possession, it is claimed only that the claimant recognizes the title of the opposite party against whom such claim is made. Moreover, here the defendant number 2 has no counterclaim on the basis of plea of adverse possession. So title of plaintiff over the suit land can be said to be deemed to be admitted by defendant number 2. Keeping aside all above facts and circumstances, if it is taken into consideration on the basis of endorsement in Exhibit 8, Exhibit 8.1, that the defendant number 2 become the pattada in respect of the suit on the basis of the sale, I found nothing from available on record that there is any sale transaction between the plaintiff and the defendant number 2, Sri Pradeep Kumar Sharma. So, but Pradeep Kumar Sharma and defendant number 2 cannot have in between that there is any sale transaction between plaintiff and defendant number 2, because Pradeep Kumar Sharma's grandfather has purchased. This cannot be, there cannot be a transaction between the plaintiff and Pradeep Kumar Sharma, because the statement was
Purchased from whom?
from the predecessor of the plaintiff. That was Gunohi Ram Sharma. It came from Gunohi Ram Sharma to Mahesh Sharma to Pradeep Sharma. So, but here the court held
Gunobhiram Sharma was the grandfather of the
Pradeep Sharma,
defendant number 2.
He purchased from the plaintiffs.
From whom Gunobhiram Sharma
Malat,
purchased?
here it is in his written statement, he has stated, Malat.
No, whether you are able to prove that court is holding that trial court has held that.
Because I am not appearing for defendant number 2, Malat. I am appearing only for defendant number 1, who is in position. He only filed a written statement and he never appeared before the court.
Okay, read further. Because still now the trial court's reasoning is that since plaintiff is also claiming to be owner of the suit land and you are claiming you have purchased from.
There is a sale deed.
Purchased from a
registered sale deed.
Person who inherited it
from the grandfather.
From his grandfather who has purchased it from the owner.
But here the court also held there is no transaction between Pradeep Sharma, defendant number 2.
No, that even if that we ignore, that there may not be any transaction between defendant number 2 and the plaintiff. But the reasoning of the trial court is that the person from whom you are claiming to have purchased the suit land there is nothing on record to show that he had a better title than the plaintiff.
If I put it in the alternative, subject to limitations, I raised the point of maintainability that is there. I will come back to maintainability. And I raised the point of 34. Court, by citing one decision, one paragraph without overlooking the second paragraph, has said that the suit is maintainable. I will place all the decision on the point of 34 itself. Suit cannot be maintainable if the sale deed is not challenged. They are saying that they want a cash position. I have purchased a land through a sale deed and I am in possession. If the suit is not maintainable, why these issues will come? 34 is the decision on which the learned trial court placed reliance on and the appellate court. They have just taken out one paragraph of it, not the whole one. And that judgment itself is in my favor, showing that the suit is not maintainable. If the sale deed.
So you want that issue to be
That sale deed is not challenged, the suit is not maintainable.
So that law point is to be formulated.
My lord, 34, because that is the substantial question of
Okay.
the problem of my eyes, man. Just but I will read again from the middle portion. And in case the entry, the name of defendant number 2, if is on the basis of inheritance, it has to be proved that Pradeep Sharma is the defendant number 2, is the legal heir of plenty who is apparently not correct. Now, this portion I have not understood. See, I found nothing from the available materials on record that there is any sale transaction between plaintiff and defendant number 2. That cannot be.
That you are also not claiming that.
My lord,
You are also not claiming
that,
that you have purchased from plaintiff.
no, I have purchased from Pradeep Sharma.
Pradeep Sharma.
Pradeep Sharma.
That is defendant number 2.
2.
And defendant number 2 has in his
Inherited from Gunobi Mahesh.
Yes.
And in case of entry of name of defendant number 2, that is exhibit 8, my entry, that name, the Patta's name, exhibit 8 was there.
Yes.
If is on the basis of inheritance, it has to be proved that Pradeep Sharma is the defendant number 2, is the legal heir of the plaintiff. How could he be the legal heir of the plaintiff, my lord? Which is apparently not correct. On the other hand, PW1 deposed that during her evidence that in the year 2000, knowing about such fraudulent act of entering his name in the Jamabandi, she challenged the very mutation before the Revenue Authority. The PW1 has also deposed that upon inquiry, she also came to know via Exhibit 9, the certified copy of mutation order passed in KP Patta number. Though Exhibit 8, here your lordship will find, shows that on the basis of KP number, name of Pradeep Sharma, that is defendant number 2, came to the records of right as Pattada in respect of the suit land. This is there, Exhibit 8. And Exhibit 8, your lordship will find, is I think from the by the side of the plaintiff. That is that page your lordship will find. Page 23, Exhibit 8 is by the plaintiff.
Okay.
That very mutation case has been filed by one C. Suresh Kumar Agrawal, not by defendant number 2. Moreover, the Exhibit 9, the copy of the order passed in the said mutation case, also confirms the fact that the said mutation case was dismissed on one by concerned authority. The entry of the name of Revenue 2 in the revenue record on the basis of KP number, which is well has been dismissed, apparently seems to be fraudulent. Next, madam. Thus, from the foregoing this discussion, it appears plaintiff has been able to prove prima facie she has the title over the suit land, whereas the defendant number 1 claiming right over the suit land and the defendant number 2 has failed to prove that his vendor has the better and valid title over the suit land, being inherited the same from his predecessor in interest. So, my view, the preponderance of probabilities lies in favor of the plaintiff, as she has the better title over the suit land. According to the plaintiff, can be said to have right title interest over the suit land. Now, my lord, this discussion, before I go to this discussion at para 18, I take your lordship to the question of maintainability. Issue number, my lord, 1, that is at page 22.
Yes.
The defendant in his written statement, in their respective written statements, have taken the plea that the suit is not maintainable, as maintainable in facts as well as in law. However, no specific plea has been made on what ground same is not maintainable. It is well settled principle of law, denial must be with specific averment. As such, in absence of any specific ground as to the non-maintainability, same is not tenable in the eye of law. On the other hand, the suit being instituted claiming right title interest recovery of possession of land, and permanent injunction. Not only recovery, confirmation of possession was also there. And for permanent injunction is very much maintainable under civil procedure code. Accordingly, this issue is decided in affirmative in favor of the plaintiff. Now I take your lordship to the question of section 34. That is
No,
at
but
page.
why you have not specifically pleaded in your?
Now, because this 34 that I have raised, 34 itself shows that if you don't
No,
challenge the sale.
The trial court has discarded your question, point of maintainability.
Because, my lord, the trial court on discussion of 34 has not been able to make out the case that it is not maintainable on that ground. That discussion is there at page 20.
Listen to my query.
My lord.
Trial court discarded the point of maintainability only on a small issue. That is, you have failed to ever make averment as to on what grounds the suit is not maintainable. You have not distinctly
My lord,
pleaded the
if I
facts.
write in the written statement, the suit is not maintainable, and I raise the law point before the trial court, and he discusses the law point, is it not necessary that he has come to a finding that suit is not maintainable?
But there is no indication that you have.
My lord, that at page 28, your lordship will find the law point I have raised. Page 28.
28. Where?
Para 18.
Okay.
On the basis of foregoing discussion, this court has arrived at a decision that plaintiff have right title interest over the suit land. The learned counsel for the defendant, on the other hand, has submitted through his argument that the plaintiff failed to seek any consequential relief. This suit is barred under section 34 of Specific Relief Act. He has also placed reliance upon such and such. I will rely, my lord, this judgment I will rely. He quoted only one paragraph. It held that in the suit seeking declaration of title of ownership of property without seeking possession, when plaintiff is not in possession, is not maintainable. In the present suit, the plaintiff has sought the recovery of khas possession and also permanent injunction against the defendants, which are clearly consequential relief. As such, claim of the defendant is not at all tenable under the present circumstances of the suit. Now, coming to the question whether the plaintiff is entitled to such consequential relief on the basis of such declaration of right title interest, it appears from the pleading the plaintiff admittedly defendants are in possession of the suit land. It is admitted that we are in possession. By constructing permanent structures thereon, the defendant number 2 in his pleading and evidence has submitted that the suit land is now in possession of them. Thus, in view of the discussion and decision arrived at of issue number 3 as above, since right title interest has been established over the suit land, so it can be we said the plaintiff is entitled to recovery of possession by removing the defendant such and such. This point was 34 has never been discussed subject to limitation, and my lord, appellate court has not decided this 34 anywhere. I don't find any discussion in the appellate court judgment of section 34. And my lord, your lordship, 2012.
What substantial question you have proposed?
My lord, that this itself is enough, my lord, this one. Page 3, your lordship will get it. No, total. My lord, for whether the suit is maintainable under section 34 of the Specific Relief Act without the prayer for cancellation of the sale date.
Yes.
And my lord, this trial court, my lord, relying on that judgment, my lord, my lord, that is that your lordship will find regarding section 34, it has been decided in paragraph that is at paragraph 55 to 57, my lord.
Oh.
That 2012, my lord, though I gave the list of books, my lord, it's not possible because these are big judgments. I cannot bring out all these copies, my lord.
Citation this
2012 8 SSC page 148.
authorized, authorized,
এত বড় বড় judgment করতে
no, authorized.
আমার কাছে আপনি কি পান এগুলো decide করতে হবে। My lord, that judgment of 34,
What is the citation?
2012 8 SCC, page 148. Paragraph 55 and 57.
Yes, please read. Ibrahimuddin.
Ibrahimuddin. Though, my lord, the Honorable Trial Court, while deciding that they have stated only one paragraph of that judgment and said that it is why it is held that the suit of such and such, they have claim for khas position, the suit is maintainable. But we have raised the point that the sale deed was not never challenged. So the trial court only quoting that he if he has
No. Actually, what was proper, so as to no, so that no confusion could be there. You could have specifically pleaded in your written statement that since no challenge to sale deed has been made, therefore it is barred by section 30.
My lord, here, my lord, that is the substantial question of law. My lord, my whole question is the subject. Again, I'm saying too much of humility. I'm saying when I have raised the point of maintainability and I have argued on the law point, because law point is need not to be laid down, my lord, in the plaint. The facts is enough for me to, my lord.
No, but
and it is admitted, my lord, they have not till now, till today. My instruction goes the sale deed is not under challenge, and it is a registered sale deed. My lord, if I think it, my lord, my second appeal is dismissed. My lord, I am in position. And my lord, the Supreme Court also dismisses my case. Then, my lord, what will happen to the registered sale deed? That will remain as in the papers, my lord. A registered document.
no, I am only concerned, is there any material to show that you raised this point?
But this I have raised before the trial court.
Wait.
That is in para 18.
18.
On the basis of the foregoing decision, the court has arrived at a decision. Plaintiff has right title interest over the suit land. The learned counsel for the defendant, on the other hand, has submitted through his argument as the plaintiff failed to seek any consequential relief.
It does not make clear that.
Consequential relief it itself shows, man, because he has relied on that judgment where it says if you don't challenge, then you will not get the relief. That judgment where he relies on, my lord, where it says, my lord, in an instant case, the suit for title of ownership has been filed. The respondent number 1, plaintiff has admittedly not in position of the suit.
On reading para 18, on reading para 18,
my lord,
it appears that the trial court was under impression that apart from declaration of right title and interest, whether recovery of khas possession was prayed for or not.
My lord, if there's some wrong is, my lord, because section 34 specifically says, and everywhere all the judgment says, my lord, the sale deed was there. It was exhibited in original. It was before the court.
Yes.
And the court came to know that the sale through defendant number 1 is in position through the sale deed.
No, I understand your submission, but I am only searching on the record. Where is the material to show that you put this to challenge that sale deed was never challenged? Whether in your argument, your arguments are also not reflected in the.
My lord, here it is said that consequential relief itself shows that sale deed is a consequential that has to be. Until unless the sale deed is challenged, it cannot be taken into position.
Okay.
Position cannot be given until the sale deed is challenged. I place all the decisions of this court, my lord. And that Ibrahim itself says, my lord, para 57, it has said, my lord, he has relied upon, I will read this para 55 to 58, my lord. The court held in a suit, in page 28, in a suit seeking declaration of title of ownership of property without seeking possession, the plaintiff are not in, when plaintiff not in possession is not maintainable. My lord, here what the Supreme Court, Honorable Supreme Court has said, The section provides, while discussing section 34, I read it slowly, my lord. The section provides that court has discretion as to declaration of status of right. However, it carves out an exception that a court shall not make any such declaration of status of right where the complainant, being able to seek further relief, that a mere declaration of title omits to do so. He has omitted to do so. In Ramchandra such and such, the court has categorically held that suit seeking for declaration of title of ownership where possession is not sought, it hit the proviso of section 34 of the Special Relief Act and thus not maintainable. In such and such, the court dealt with a similar issue where plaintiff was not in exclusive possession of property and had filed a suit seeking declaration of title of ownership. Similar view has been reiterated in objection, observing that the suit is not maintainable, is barred under provision 34. In view of the above, the law becomes crystal clear. It is not permissible to claim the relief of declaration without seeking consequential relief. In the instant case, in that particular case, the suit for declaration of title of ownership had been filed. Though the respondent number 1, plaintiff, has admittedly not in possession of the suit property. Thus, the suit is barred by proviso of section 34 of the Specific Relief Act and therefore ought to have dismissed solely on that ground. The High Court, though framed a substantial question on this point, but for unknown reason did not consider it proper to decide the same. And here, my lord, your lordship, if your lordship look into that appellate court judgment, my lord, subject to correction again, my lord, I don't find a single discussion on this point of 30K. Page 39 at the point of determination.
Yes.
My lord, till 42 is the judgment, my lord, not a single word whisper about 34. And my lord, another judgment of this court, my lord, I will rely upon 2000. My lord, first of all, I will rely on, my lord, 2016.
So, according to you, only this is the substantial question of law.
The suit is not maintainable if under 34, the sale deed is not under challenge. Until now, my instruction goes subject to correction because earlier some other counsel has there. I have recently been given, my lord. And this judgment, your lordship may just look into this judgment, my lord. 2006, 16.3 GLT page 127. 16.3 GLT page 127. Para 37.
2006.
16. 2016 3 GLT page 127. Para 37. My lord, I will read it slowly, my lord.
Yes.
My lord, may I read it slowly?
Yes.
In the facts of the case, a prayer for cancellation of Exhibit A as a consequential relief was necessary to enable the plaintiff to get a decree declaring his right, title, and interest. It was incumbent upon the plaintiff to have challenged the sale deed. It must not be forgotten that suit land was mutilated in the name of vendors by the sale deed by way of inheritance. There was no objection by the plaintiff in such mutation. That about that number were also wrongly given in the gift deed. Exhibit 1 is the same, was not corrected and rectified. Without there being any challenge to Exhibit A, the learned court below proceeded to embark upon an inquiry to find out the legality and validity of the sale deed and whether the defendant number 14 could have taken possession by virtue of a sale deed. The exercise taken by the court below was impermissible in law. In absence of a declaration that the sale deed is invalid in law, which was not sought for, learned counsel sought for learned court below could not have granted decree declaring title interest for the plaintiff for recovery of cash possession from defendant number 4 in respect of the land. And my lord, another judgment that I will rely, my lord, 2008 2 SCC, my lord.
No. We are now deciding what substantial question of law. This no longer remains substantial question. It has already been settled by this court as well as Apex Court.
That if the sale deed is not under challenge, then my lord, and thereupon, my lord, this argument was there, and the appellate court has not made a single whisper on that. Not a single
No,
line.
make me understand. We can exercise jurisdiction under section 100
My lord,
only when substantial question of law is involved.
my lord.
This question that when sale deed is there, unless it is challenged, has already been settled by
And
this.
sir, my lord, when it is settled, the suit is not maintainable.
No, listen to my query.
My lord.
This is only a case where, if we agree to your submission,
My lord.
this is only a case where there is wrong application of law.
My lord.
Then in case of wrong application of law,
My lord.
whether section 100 can be invoked, this question could have been raised before the first appellate court.
My lord, if from the judgment, what I find, my lord, while recording in the appellate court judgment, the defendant's case, the appellant's case thereon, my lord, your lordship may look into the appellant's case.
Okay, let us.
And my lord, regarding, my lord, a substantial question of law, my lord, this judgment I am relying upon, my lord.
The judgment.
8, 9, 12, and 14, my lord.
Citation.
Citation, my lord, here. I'm giving this, my lord. Yeah, yeah. It is, my lord, reported in SCC will be there, my lord. 23 at Supreme Court.
What is the name of the parties?
My lord, this is Apaya versus.
Apaya, I have a copy. Which para?
My lord, 8, 9, 12, and 14.
What?
Para 12, my lord, I will read it, my lord.
Yes.
In the decision of such and such, it was held that in order to be substantial question of law, the test is whether it is for general public importance or whether it is directly or substantially affects the right of the parties. Whether the question is still open, it is not finally settled by the Supreme Court, such and such. And 14, my lord, a point of law which admits of no true opinion made by may be a proposition of law, but cannot be a substantial question of law. To be substantial, a question of law must be debatable, not previously settled by law.
Goes against you.
But here, your lordship will find it affects the right of the parties, my lord. It will affect my right, my lord. I am in position through a sale.
No, but it is not finally settled.
But my lord, if ignoring the law which has been settled down by the court, can the trial court go beyond that, my lord?
That question is to be raised before the first appellate court.
But if it was raised and it was not discussed, then what is it not, my lord? My lord, here everything by your lordship will find the judgment is of 2, 3, 4 pages, and not a single whisper about anything, my lord. This judgment, your lordship may look into the appellate court judgment, my lord. Point 1 and point 2, my lord. Only those two, and nothing has been given, my lord. Nothing has been said here. Was it not necessary for the appellate court to look into everything, my lord, of the trial court judgment? When it was raised before the trial court, it was said no against me, my lord.
Where is the memo of appeal?
Memo of appeal, my lord, maybe in the record, my lord. I don't. I can ask you.
Yes. So just before you start, just a minute. So which substantial question of law you are proposing? Number 3.
Number 4, my lord. 4. And my lord, another one thing, after we are directed to go for the additional evidence, my lord, we have brought one O as an exhibit before the court, my lord, on additional evidence, where the defendant number 2 filed a suit against number 2 and others, my lord, and his right title interests were declared upon him by a civil court. My lord. This was Exhibit O, defendant number 2. When this court directed us to go for the.
It's not related. First of all, his vendor is a fraudster declared by the revenue board.
His vendor?
Yes, his vendor. His so-called vendor,
Ah.
Mahesh Sharma. His entire fraudulent act that has been reflected in the judicial order, affirmed by the High Court. What happened? Originally in pattern number 44, only name is Prafullamoyi. Exhibit 15, my lord. Exhibit 15 shows that the draft chitta of 1975 and 76, in pattern number 44, the only name appeared there, Prafullamoyi. Now in 2000, if your lordship see Exhibit 8, then all of a sudden the name of Pradeep Sharma has been entered as number 2. And the noting of that, my lord, at Exhibit 8, saying that on the basis of purchase and by right of inheritance, his name was entered into. No name of the Gunabharam, no name of his Mahesh Sharma, his father, nothing. And therefore, there is serious doubt raised in the revenue proceedings. How his name entered all of a sudden. There was no reference of the deed number, but saying that in the note that Khorid Dokhol Aru Uttaragiri. Now there is another interesting point, which my learned friend did not mention, that the number of the mutation case, application number, the mutation case number. Now when it went to the revenue board called all the records and found that that mutation application has been submitted by one Mr. Agara, Surya sir. And that is the finding of the revenue board judgment. And the revenue board judgment saying that to maintain a status.
Who went to revenue board?
We.
What happened in revenue?
We challenged his mutation. Once his mutation 2000 Javamundi.
Yes, what happened there?
Then all set aside by the revenue board and call for there was a direction for initiating of the disciplinary proceeding by the revenue board. And there is a clear findings. May I read, my lord? This is Exhibit 8. My lord, kindly take a note because we are not pressing, my lord, to dispose the matter finally because there is no substantial question of law. Now, even if there is absolutely a fraudulent act which is also reflected, what happened, my lord? This filing of this second appeal, the matter has been taken up by a court, one continuous bench of this own court. Then continuance was found that there is some 2 or 3 Jamamandis, etc. at the hearing. Then the continuance bench by an order dated 24/1/2020 remanded them for additional evidence.
Without admitting the appeal.
Without admitting it. Be that it may, my lord. Now this is the order of this court. So additional evidence was taken. I mean, the additional evidence that Exhibit 15 and 16 was exhibited by us. Exhibit 15 is 75-76, that revenue, there's records of the revenue. And 16 is, my lord, the Board of Revenue judgment. Now, Board of Revenue judgment, which was also challenged before the High Court, my lord, that was disposed in the suit is pending in view of that. Now, a Board of Revenue judgment, the Pradeep Sharma's mutation order was set aside.
It was challenged before High Court.
It was challenged before the High Court.
What happened?
And the High Court saying that since the status quo has been passed by the Revenue Board, it will continue because the appeal is pending therein.
This appeal?
No, the second appeal. Not this appeal, second appeal. I'm sorry, first appeal, because High Court's judgment was
First appeal
in
from which
2011.
this appeal has arisen.
Yes. At the time of the filing of the writ petition against the Revenue Board judgment, the first appeal was pending. Already the suit was decreed. Now the High Court says that since the status quo order is continuing and the appeal is pending, so let the matter be decided then.
And the
So
writ
not
petition-
interfere with the Revenue Board judgment. So it was reaches its finality.
Oh.
So in the Revenue Board judgment, my lord, the lordship is right. In Revenue Board judgment, I'm just relevant paragraphs. May read, my lord. Because it's relevant, but just to understand that section 34 will come or not, because we are not going to challenge that sale. It is not required. It is not required. It is not binding upon a person. That is relating to separate land. That's the what happened. Lordship is correctly pointed out that the defendant, in fact, in this second appeal memo, the defendant number 2's written statement not included, annexed to it. Now, Lordship is correctly pointed out that the reference of this deed, this original 55 deeds, that was not referred by Pradeep Sharma. This is defendant number 2. He in the paragraph 12 in his W is saying that right of adverse position. And he has not referred of his grandfather's deed. It was referred only by the defendant number 1. And that deed having no relation with this suit.
No, still, when there is a sale deed in the name of the present appellant.
No, there is a difference, slight difference, the which is carving out, my lord.
Yes.
And my respectful submission is, what I understood, that when the sale deed to be challenged, if it is the same parties, or between the claiming the title arising out of the sale.
No, if the sale is in respect of,
Yes.
no, if it is in respect of the land over which you are claiming ownership.
They are separate, the separate patta, my lord. They claiming the title on the basis of a Pradeep Sharma's title. Now, Pradeep Sharma, how came? He said, I am a grandchildren of Guna Vivaram. So I inherited. So if that 1955 did to be seen, the schedule, absolutely different dag and patta. Not related with us. Why should we challenge? When the cause of action of the suit arose, my lord.
In the Exhibit G.
The G.
The schedule of the sale deed, schedule of the land, whether it tallies with your land or not.
That dag number, patta number tallies with me, my lord. But why we are not challenging? The vendors having no title. If a person match with my dag number and patta number, that sale deed is not binding upon me. If sale deed is not binding upon my title, there is no question of challenging. Because it is their case to file a counterclaim that this sale deed is binding upon you. It is their claim. We say, because how the suit came in? The suit came in when I found Pradeep Sharma's name in the My Jamamandi. Then it shocks my mind how his name is came in. Now, in that note, my lord, there was no reference of sale deed, etc. Immediately we filed a suit challenging, and we found that he is taken the possession of the land and constructed something. Then we filed a suit for confirmation of title and the recovery of possession. And both the concurrent finding is that we proved our title. And lordship is fine that his vendor's title that is clouded and finding by a revenue authority itself. Because his entry in My Jamamandi itself fraudulent. How could he transfer the land, my lord? So, therefore, I am requesting my lord to just see the exhibit 16, that is the Board of Revenue judgment.
No, no. Now we have to decide whether any substantial question of law is involved or not.
Correct. Correct.
Because unless we decide that, if there is nothing, the suit will not be admitted.
Correct.
We cannot go beyond that. If we find some substantial question of law, then as the records are before us, we will frame it and fix the matter for hearing. So your submission has to be, your submission has to be that there is no substantial question of law.
Absolutely not. Because the lordship will find, they are only pressing section 34.
Yes.
The section 34 is when come, madam. If I omit to pray something and I cannot pray subsequently, that's the section 34. Now, what the consequential relief I am praying for here? I am praying for title and recovery of possession. So I am required to prove my title only. So for my title is concerned, to prove, I prove my patta, my entry in Jamabandi, my revenue payment receipts, etc. And
is
also,
it not required to challenge some a sale deed which clouds your title?
and I'm answering this query. So therefore, my prayer is title. So therefore, I am proving my title. Now, since I am proving my title, my consequential relief is recovery of possession, not challenging that title or his mutation. Because I am challenging his mutation in separate proceeding, while I am a success. And that was confirmed. So therefore, if the vendor's mutation itself goes, so why the sale stands, my lord? Even if, my lord, even suppose for argument's sake, if this sale deed stands today is also, naturally I am not challenging his stance. This sale deed is on paper sale deed, my lord, registered sale deed, having no binding effect, because his vendor's mutation already cancelled. And it is decided by the revenue authority that he obtained the mutation fraudulent way. So that judgment is on the shoulder of my learned friend. So therefore, otherwise also, section 34 will not come. Section 34 would come, what I understood, on the basis of a judgment of the Ibrahuddin Medor, which is well recognized, we'll talk about every time we are pleased, this judgment before this court. Now, what I am understood, if I am proving my title without recovery of possession, then that is a consequential. I'm seeking recovery of possession without praying for a declaration, my lord, of right title. That's the bad in law under section 30. Or in vice versa, if I am seeking right title and I am not in a position, but I'm not seeking recovery of possession, that's the consequential relief.
If you don't challenge the sale deed, what would be the consequence?
Nothing. Nothing, my lord. Nothing. If I am not asking for cancellation of the sale deed, nothing. It is not binding upon me. If the sale deed is binding upon me, then I have to challenge it. This is not binding upon me. When a sale deed to be cancelled, then the competent authority, as the statute defined, cancelled the mutation of his vendor. And his name was not entered into the revenue records. He having only that piece of that paper only, madam. And this Prafulla Sharma, his vendor's entry has been cancelled. So what will be the consequential effect of that, my lord, of that revenue board judgment? That his vendor is no more. Now, if the identity of his vendor is doubtful, my lord, then the entire sale deed will go automatically. Now, that's the question, my lord. So therefore, the consequential relief is what the judgment says, what I understood, my lord, that the consequent relief is, the main relief is, my lord, the seeking title, declaration of right title interest, which I am asked for, and consequent relief thereof is the recovery of possession, which I am prayed for, my lord. So therefore, there cannot be a to be constitute a substantial question which is not existence in the records, in the pleadings. So because this appellant, my lord, before this honorable court, never stated either in his WS or in the memo of appeal before the first appellate court. His WS, what is his stand, my lord, in that written statement of the head? His stand in the WS that the original owner Gunabhiram, then Mohesh Sharma, then Pradeep Sharma, then he had purchased. That is his stand. Now it is contradicted by the Pradeep Sharma's WS. Pradeep Sharma says otherwise. Pradeep Sharma says that no, I am not claiming title on the basis of the sale deed of 1955 or from the Gunabhiram inherited by Gunabhiram Sharma. He himself take a different stand and saying that my stand is, my claim is adverse possession, and which is not perfected by any title, by any decree of the court, my lord. So therefore, both the defendant number vendor and the purchaser, they have taken a contradictory stand. So therefore, they cannot say now that the section 34 take the benefit of the section 34. The suit is not maintained.
Okay, the judgment of the revenue board is in records.
Yes, my lord. What I am proposing, my lord, when lordship is here, the order 41 rule 11 application, this question of substantial question of law, is settled position of law by a Supreme Court judgment, or also coordinated with judgment of this court, my lord, that we can dispose the entire matter. Entire matter. Not only the question of the substantial question of law, and also can go into the merit of the matter.
No merit unless there is a substantial question of law.
Now, while deciding this, the entire matter can be disposed of.
That whether there is a substantial question of
Yes,
law or not.
yes, yes. So that is my respectful submission. And while deciding so, my lord, the materials on record, since the record is here, lordship may. But so for end of the matter, because it's about all pending matter, the decree is decades old, my lord. So therefore, for a substantial justice for both the parties, matter should be end. So therefore, lordship may, if lordship deem it fit and proper, may peruse the exhibited document. And therefore, what I am pointing out to this honorable court, my lord, that the title I have proved, my patta was there of patta number 44. My Javamandi was there, 1970, exhibit 15. That 75, lordship will find my name is only Prafulla Moi. Nobody there. No, abruptly, suddenly, all of a sudden, Pradeep Sharma entered into in 2000. In 2000 by exhibit 8. By exhibit 8, my lord, Jamabandi in 2008 to 2000, exhibit 8. The defendant number 2's
No,
name.
these facts are clear.
Right.
These facts are observed by the trial court also. That the till 2000 name of Kiran Moi was there. Prafulla Moi was there.
Then he entered just like a Hindi cinema, my lord.
No, what I want you to address mainly that whether without challenging the sale deed, the suit of the plaintiff is maintainable or not.
No, my first submission is. my
And,
first-
and whether this can be a substantial question of law at
Correct.
this stage.
No, why I'm saying no, my lord, with all fairness. First submission is, my lord, that when the query, the answer to this query is, my lord, the first proposition of law is that when a sale deed is to be challenged. My respectful submission is that a sale deed can be challenged by whom? How the legal right can be accrued to challenge a sale deed. Now, it is a dispute between the parties of the sale deed, number one. Number two is, if by the legal representative of the vendors and the purchasers. And number three is, if the sale deed is directly impacted upon the right, title, and interest of the person concerned, of the suitor. And most importantly, if the sale deed is on the face of it is apparent is a fraudulent, no decree is required. Why I'm saying so? If the sale deed is executed by a declaration by a competent authority, the sale deed, yes, this sale deed has been executed by a dead person. It is an observation by a competent authority. I need not to challenge it through a suit. Again, for reconfirmation. Now, here in this case, the authority, competent statutory authority,
Revenue Board.
yes, under the Land and Revenue Regulation 86, competent to decide the correctness of the mutation, legality of the mutation under the Act, decided that is a fraudulent entry of the header of this defendant number 1, my lord. So therefore, it did not to be decided by a civil court. These are fourth proposition, my lord. My first proposition is this: there are some parameters wherein the sale deed is required to be challenged, and by whom the sale deed to be required to be challenged. And fourth proposition, what I am addressing this court, my lord, that if the apparent on the face of it is seen, because the sale deed, when I would to challenge, my lord, if it confers a title, which I am saying that he cannot confer the title. Why? Because he having no title. Now it is in this case, in the instant case, interestingly, the person who had executed the sale deed, his name is not there. His name is not there, my lord, in the revenue records. So therefore, how he has an authority to execute the sale deed? And it is decided by a competent authority. So therefore, it cannot be decided again parallelly by a civil court. But there is a bar. They can agitate this by encounter, which they did.
Claiming their right on the basis of.
Which they have failed to do so. Even if the Board of Authority, Revenue Board is the final authority, my lord, it is a settled law. The decision of a Board of Authority, this Revenue Court or the Revenue Authority, subject to the final outcome of the civil court. But who will challenge, my lord? Who will ask for? The person who having that sale deed in his hand, who claim the right title interest, he has to seek a declaration, my lord, to having a title validly conferred by his vendor, and therefore he is claiming the title of this. It is his duty to. It is not mine. So he cannot shift the burden to me and saying that the suit is not maintainable. So this is, yeah, I hope I clarify this matter.
I have a small reply. Yes. My lord, revenue board cannot go by the sale date. It's only the mutation. Section 50 says it does not confer any title. My lord, mutation is only as regards title accompanied by possession. Page 24, my lord, it shows defendant number 2 name appeared as a pattadar after the printing. Your lordship will look into it. Patta cannot be cancelled by a mutation, my lord. Mutation and pattadar are different. Your lordship may look into page 24. After Prafullumoyi, my name appears as a pattadar. Your lordship, it is a finding of the trial court. Your lordship will look into it. It appears as a pattadar. Mutation is different, my lord.
Okay.
Sale deed now, but it is their suit. They have come, my lord, before this court. And my lord, that I will just place it, my lord. That just after the name of the plaintiff Profundo Moi Chaudhuri as pattadar of the land of tag number such and such, name of the defendant number 2 appears as pattadar.
In the Jamabandi.
My lord, pattadar is a pattadar. However, interestingly, Exhibit 8.1, the comment endorsed in the document, it appears the name of positional defendant 2 came as a pattadar of the land on the basis of her sale and also by way of inheritance as per.
What is 8? 8 is Jamabandi.
Jamabandi.
And that has been, that mutation has been.
Yeah, they have cancelled. But it was there, they have cancelled the mutation. They have not cancelled that patta. Well, those things has to be decided by in the suit, their suit, my lord. Their suit. I have obtained a sale deed, my lord, because the mutation has gone, so the sale deed is also gone. Can that be an argument, my lord? Can a revenue court override the civil sale deed, my lord? As under the Transfer of Property Act, the sale deed is made. On that basis, can the revenue board can decide anything of a sale deed? The mutation has gone, so it is gone. Sometimes the mutation is given on the basis of the position also, man. Maybe a sale deed, maybe of.
So his submission is, suppose A has right title and interest over plot of land. C and D are total strangers. C sells the said land to D. Whether A is required and
after coming to know, A and B coming to know.
Then just a minute. C sells the said land to D. Similarly, again, one E sell the said land to F. Whether he is to challenge every sale deed.
Now the question is who is in position. If I find that the position belongs to, now is sitting over is D, E and F, to throw them out. If I come to know the sale deed is there, whoever it is, they have vendors as sale deed. Was it not when my title is in under cloud? So,
to challenge the sale deed.
To challenge the sale deed. The position, they are not in position. We are in position. It will affect me, Malad. They will throw me out. The whole title is under cloud, Malad. They came to know about the sale deed. And it is their suit. They want for a cast position. And in that judgment, where I have asked for the substantial question of law, your lordship has also said that, Malad,
wrong application of law.
Malad, here also, Malad, in that judgment, Malad, paragraph 12, Malad, regarding that apaya, Malad, there also in paragraph 12 also it has said, Malad, that when Malad, particularly some question of law was there, it was raised earlier also, not decided. It is not the matter, maybe the vendor title is not there, their mutation is cancelled, but sale deed is there in front of the plaintiff. Their titles are under cloud.
12 says something different.
Malad, page para 12.
Para 12 says.
Malad, para 12, the proper test for Malad in page 5 of 11. It says that directly and substantially affects the rights of the parties. it will affect the right of the party, my lord. I am in position, I have constructed therein, I am in position and I am, my lord, settled over there. Only by assumption that sale deed will become bad, my lord.
Okay.
Because mutation has gone, sale deed is become bad.
Mr. P.K. Roy Chaudhary, Learned Senior Counsel assisted by Ms. R. Roy, Learned Counsel for the appellants. Also Mr. B. Datta, Learned Senior Counsel, appearing assisted by Mr. S. Dekar, Learned Counsel for the respondent. Heard the parties under Order 41, Rule 11 of the CPC. Release this matter for delivery of orders on next Monday. Enough time like on 23rd June.
Well, obvious, grateful. Obliged.
I missed out on my lord, the motion.
I can take it.
Yes.
But we have filed a title suit, my lord. What happened, my lord, one machine was Taber's block manufacturing machine. That was supplied to us. That was defective and not functioning well. We have filed a suit, my lord, for compensation, etc. Oh, sorry.
Yes.
Now they have appeared, my lord, the defendant has appeared and filed that their WS. Along with the WS, one application under section 5, 8 of the Arbitration and Conciliation Act 1996 for referring the dispute, my lord, has been filed.
Yes.
And thereafter, after 1 month, they have again filed an additional written statement. Then
What happened to that 8 petition?
8 petition, my lord. Then the 8 we have filed our objection against that.
Section 8 is on the basis of quotation.
Now that was rejected by the trial court and they preferred an appeal. Then the appeal was allowed and consequently section 8 application was allowed. The basic contention of the section 8 application is, they said that we have issued a quotation, my lord, to the plaintiff. The defendant saying that we have issued a quotation and in the quotation
against that appellate court's order.
Yes. Against that appellate court judgment, my lord.
What is the stage of arbitration?
My lord.
What is the stage?
Now the suit was stayed.
An arbitration stage?
No, nothing. No, this is a recent judgment. So we have challenged immediately. Arbitration was not. Now why we are opposing section 8 application? My lord?
No, while referring the matter to arbitration, any date has been fixed?
No. They just stayed the suit and
then we'll issue notice.
Yes. Just to stay the matter, my lord, that judgment of the appellate court judgment. Otherwise, my lord, if they will initiate, then the entire matter will be infructuous. That's the only prayer. Because prima facie, my lord, the section 8 application not maintainable. They said the quotation, and the quotation was not saying nothing. That quotation. Therein is clause 23, and that clause 23 is also not saying that there is 3 conditions. Saying that if the mutual settlement is failed, then the mutual consent by appointment of the arbitrator, and third is written notice. So that is not an arbitration clause as the Supreme Court judgment. This is number 1. Number 2, that is a quotation not accepted by us.
By signing.
By any acknowledgement or any communication, my lord. And that which the section 8(2) says, my lord, that if the application has to be filed, along with the application, you have to require to file the original copy of the arbitration agreement or the certified copy. Now, what they have filed, they filed an unsigned quotation, my lord.
Email.
A mail copy.
Here is no.
So therefore, prima facie, my lord, the section 8 application is not maintained.
Heard. Mr. B. Datta, learned counsel, senior counsel assisted by Mr. S. Deka, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been preferred by the petitioner, impugning the order dated order dated 26/2/2026, passed by the Court of Learned Additional District Judge Tinsukia in Miss Appeal number 31/2023, whereby the order dated 16/6/2026, passed by the Court of Learned Civil Judge Senior Division Tinsukia, rejecting the prayer for referring the matter to conciliation under Section 8 made by the present respondent was reversed, and the prayer for referring the matter to arbitration was allowed. Learned senior counsel for the petitioner submits that the basis for filing the Section 8 petition by the respondents before the trial court was an unsigned quotation, which cannot be regarded as an arbitration agreement. He also submits that, what is 23, clause 23?
23. Lordship will find at page 63. Lordship is good. All dispute arising out of this arrangement, unless settled amicably, is the first condition, shall after mutual consent.
He also submits that.
And written notice.
Last line kya tha? Before that. Agreement stop. He also submits that even the arbitration clause contained in the said unsigned quotation required some preliminary steps to be taken before a matter can be referred to arbitration, like an effort to arrive at mutual settlement, arrive at an amicable settlement,
mutual consent,
and thereafter mutual consent and
written notice.
Giving written notice, matter may be referred to conciliation. Said preliminary steps were not adhered to by the respondent side, and the
So therefore, this clause, my lord, is not binding.
Here is binding.
There's a Supreme Court judgment, my lord, saying that if there is some this clause, conditional clause, then it's not an arbitration clause. The Supreme Court judgment. Itu nahi lage.
So,
Nahi lage.
which Supreme Court
This is
judgment?
my Lord. Yes. Take me to 2007. 2007 to the 2007 to 2007 to it is এটা edition. 7 it was.
So, he submits that the appellate court
দুটা পঠাইছিল
erred in not taking into consideration these aspects.
এটাই
The who filed the suit? You were the plaintiff.
I'm the plaintiff.
The appellate.
দুটা একই পঠাইছে
The stop issue notice to the respondents. The appellant shall take steps for issuance of notice upon respondent by speed post as well as by usual mode within 7 days of the date of this order, returnable on 27 July. Till returnable date,
Right.
suit also has to remain stayed.
Should already. Oh, yes, yes.
If we stay the
Yes, yes.
order, suit will revive.
Yes, yes. Both.
Uh,
Yes, yes.
Consider-
That has to be final.
Considering the submissions made by the learned senior counsel as well as averments made in the instant petition, the impugn order dated 26 and the operation of impugn order dated 26/2/2026 passed in Miss Appeal number 31/2023 shall remain stayed. The title suit number 21 shall remain stayed till next returnable date. The title suit the proceeding of title suit number 21/2021 shall also remain stayed till next returnable date.
Right.
List according.
Right. Careful, right. Okay, get. My lord, I'm just missing out. Just argued, my lord.
We are not referring it now.
No. Earlier, second appeal case.
Huh.
Okay.
What judgment?
Man, what's the substantial recent judgment, my lord? What the substantial questions?
You mark the paragraph numbers.
Yeah, I mean, just on the top, my lord. On the top, I am.
Okay. Side of the by responding. Yes.
Right.
Okay.
Beg your indulgence, fellow. In item number 6, I am 40 respondent, my name may be recorded, man. Item number 6, man.
Item number 6, name of Mr.
BD Decker,
B.D. Decker may be
40 respondents.
B.D. Decker.
Actually, I've been told that they have not received a copy of the CRP, so a little difficulty would be there. So I'll be supplying the copy of the CRP. A date may be fixed after vacation.
Mr. R.J. Das, learned counsel for the petitioner. Also Mr. S. Islam, learned counsel for respondent number 1 and 2, who submits that he has not received the copy of the both CRP interlocutory application and copy of the revision petition. The learned counsel for the petitioner is requested to furnish the copy of the same along with annexures to the learned counsel for the respondent within 2 days from the date of this order. Let this matter be listed
After
13th of August.
can it be a little earlier?
And
A little urgency.
6th of August.
Deeply obliged.
For reasons mentioned in the judgment, this appeal is dismissed.
My God. Chocolate.
Go.
I
Go.
didn't expect that. Yes, Bachman.
Sometime unexpected things happen.
Yes, today is that day. Obliged. তোমাকে লিখলাম
I don't want.
Your Lordship, my lord, this is cases of overloading cases, my lord. Last occasion it was hard, my lord. But the Lordships are already directing me to enquire some of the queries. Already I have obtained this clarification of the
What
regarding the women chart. But the main thing is, my lord, these just in earlier occasion also number of cases already remanded back on the ground that the judgment was passed by a single bench. It should ought to be have been before the division bench. So these judgment also passed by the technical member, single bench. See, if I go through the judgment of this honorable court, my lord, the matter, there is no any authority was granted, given by the chairman of the Railway Claim Tribunal, Railway Board. So under section 4 of this, section 4 of the Railway Act, so it may be remanded back to hear matters before the by the division bench. Judgment is with me, my lord. Lordship already passed the judgment in similar matter, my lord. So,
But how can you ensure that in the year 2013 whether authority was there or not?
but yes, my
You
lord,
have
I already
verified.
inquired, my lord. The concerned officer already intimated. The authority was issued by the railway board chairman, RCT chairman, from the year 2018, not in 2013. This records with me, my lord. In the year 2018, 2020, 2022. 3 times they have authorized the RCT. Due to the long pendency of cases pending before the RCT, to say a single member can decide the matters without having a judicial member or technical member by the single bench. This is from the 2018, my lord. It is a matter of 2013.
So you are praying for remanding the matter?
Yes, my lord. I am obliging this order of the honorable court.
My lord.
I'll come to you.
In the last occasion also, they raised the same point, my lord, in my earlier case. And accordingly, this case was remanded back due to the for the constitution of the division bench, and here the matter by the division bench.
Yes.
My order,
Yes.
Lordship's order is with me, my lord.
Yes, Mr. Rathi.
My lords, there is a letter given by the Railway Claim Tribunal itself, my lord, and the Railway Board letter, my lord, it has given specific authority to adjudicate the matter which is below 2 lakh. And the matter which we are concerned of, my lords, is below 2 lakh, my lord. It's of 36,000 something.
This is from the year 2018.
No, my lord, this is on 29th April 2026. This is subsequent to the order passed by the Honorable Gauhati High Court.
But this order is passed in the year
One
2013.
by one. I'll come back to you.
By invoking, my lord, section 4.4 of the Railway Claim Tribunal, my lords.
But this order, this authority is of 29/4/2026.
Yes, my lord.
But prior to that,
Prior to that, my lords, this instruction has been given as in they can, my lords, up to 2 lakhs of the amount, my lords. And also, my lords, I would like to place reliance on one judgment of Patna High Court, my lords. It's a division bench judgment, Ranjan Roy versus Union of India. If your lordship may kindly have it. My lord, the same plea has been taken in this matter as well, saying that the member technical cannot pass the order. However, my lords, apart from, except for remanding the matter back to the Railway Claim Tribunals, this honorable court has decided the matter there itself. My lords, may kindly have para 23 if your lords.
which case?
Of Ranjan Roy, my lords, Patna High Court judgment. Just handed it over, my lords.
Yes.
My lord, at para 23, my lord, it says that for the reason aforementioned, the judgment and order impugned cannot be upheld and is accordingly set aside. The claim case is allowed. The claimant would be entitled to a compensation of so and so, would be accompanied with the interest payable at 6% so and so, filing of the claim, and until the date of the impugned order, and thereafter 9%. The appeal is allowed, but in circumstances without any order as to pause, let the lower court
No,
record be
this is the
transmitted.
outcome. Why are you referring this judgment?
My lords, because it's on the similar issue. My lord, the order was passed by the technical member of the RCT.
But whether it was pointed out to the court,
Yes, my
whether-
lord.
where is that?
My lord, that was the main issue, my lord.
Why the said objection was not considered by the court?
My lord. My lord, may I have kindly have para 12. My lord, it says that the observations are in clear breach of the judicial discipline and nothing short of contempt. The technical member has clearly exceeded the bar and does not even seem to understand the damage, the utterance, and reflect a drought of legal understanding and smacks of arrogance. Judicial discipline and judicial propriety are the backbone of the Indian justice system, and no person whatsoever can be permitted to disfigure this system, much less adjudicating authority sitting on the bottom rung of the judicial hierarchy. Is to be pending the House of President. My lords, may kindly have para 17. It says the case in hand is not an isolated instance or exception. Rather, this court has been experiencing orders passed by single member bench of the tribunal, which are nothing short of personalized opinion, are dehost to the evidence on record beyond the pleadings and ignored the settled legally binding precedent, rather in deficiency thereof. In the circumstance discussed, this court is forced to think whether the excess power of learned chairman under section 4.4 of the Railway Claim Tribunal constituting single bench is serving the object and purpose for which it was constituted or in generating litigation. The provision of section 4.2 and 4.4 of the Railway Claim Tribunal Acts and section 5.2 and subclause 6, subsection 6 of the Central Administrative Tribunal Act are identical, whereas 4.2 of the Railway Claim Tribunal Act and section 5.2 of the Administrative provides for constitution of a bench and mandate that the bench would consist of a judicial member and an administrative member. Section 4.4 of the Railway Claim Tribunal Act and section 5.6 of the Administrative Act vest power in the chairman to constitute single member benches.
My lord, in the last occasion.
My lord, please let me complete. The channel question was opening for the and my lords, after that, this judgment was filed. Instead of remanding back the matter to the RCT, the court has adjudicated the matter there itself, my lords. My lords, all I am seeking, my lord, it's a very old matter. And my lord, it's a very settled position as well, my lords. May kindly consider to adjudicate it here itself.
No, when the single member, technical member does not have jurisdiction, how the judgment gets validity? On that ground only, earlier matters were remanded back.
My lords, they have the power to decide the adjudicative matter, to rule that matter. And my lord, there is
that power is given.
Also, my lord, even if the matter has been remanded back, my lord, there is no judicial member in the Honorable RCT Gauhati. There is no judicial member, my lords. The matter will be pending for very long, my lord.
What is the
And the technical member.
What is the amount involved?
36,000, my lord.
36,000, my lords.
It is less than 2 lakhs.
But in earlier cases, my lord, last occasions, my lord, my case was only for rupees 23,000 or 5,000. So this case was as they have submitted on the basis of their condition case matter was remanded back. In my order dated 21/5/2026, my lord, that time they couldn't have raised this point, my lord. That this is the letter of the RCD chairman in the year 2026. The below 2 lakhs, the single bench can entertain this matter. My lord, here, my lord, in this order, my lord, Mr. D. Rathi, Learned Counsel for the respondent, has pointed out that since the case is impugned judgment delivered by the member technical Railway Claim Tribunal sitting singly, it is covered by the earlier judgment of this court in this regard, where it has been observed that unless the authorization under section 4.4 of the Railway Claim Tribunal Act is there, the member technical cannot dispose of the claims under section 4 of the Railway Claim Tribunal Act 1987 sitting singly. It is their submission, my lord.
This authorization is given now.
Given now, my lord, there is one thing, my lord, there is no judicial member in the Honorable RCT Guwahati, and the technical member power has been suspended, my lord. There is no point even if I go to Honorable RCT, where will I get justice, my lord, because the matter cannot be adjudicated. There is no judicial technical member's power has been suspended. The matter is of 36,000, my lords.
My lord, the last
Just
occasion
two
was
lakhs.
submitted, my lord. That due to the long pendency of the cases, my lord, technical, it is on the basis of the decisions of the Railway Claim Tribunal chairman, the technical member is passing the judgment, hearing the matter and passing the judgment, my lord. That time they raised objection, my lord. Now they are supporting, they are misleading by supporting the contradictory submissions, my lord.
Not misleading at any
My
point. There is no
because
technical member. there is no judicial member.
one order, they
Even if
denied
that's
it
been
cannot be
remanded.
entertained by the single bench.
No, the question before us is whether the order which has been impugned in this appeal was passed by a competent adjudicatory authority having jurisdiction. And on this ground, earlier also, the matters were remanded. You have cited the earlier judgment.
Yes, my lord. In MFA 30 of 2015,
Matter Asani. MFA.
MFA 30 of 2015, order passed on 21/5/2026. Already submitted, my lord.
Yes, you have any submission?
My lord.
Your submission is old pendency.
Old pendency. My
Even
lord.
if it is remanded back,
My lord, the matter
there is
cannot be
some-
adjudicated because there is no judicial member, there is no technical member. Technical members' powers have been suspended, and there is no judicial member.
by which it has been suspended, by which order?
My lords, there is a High Court order. My lords, I have produced it. If your lordship may kindly have. Writ petition 2736 of 2026.
Which para?
Para number 8. My lord, it says, after considering the facts and circumstances and also the reasoning recorded by the Honorable Gujarat High Court in the order mentioned above and the order dated 15/10/2025, this court is of the opinion that the issue would require some deliberation. Therefore, to balance the equity and the interest of justice, it is directed that till the returnable date impugned communication dated 29/4/2026 shall remain suspended so far as the case of the petitioner is concerned.
Only with regard to that specific case. So far as the case of the petitioner is concerned,
My
it
lord,
does not put a halt, complete stay on that notification.
My lords, even if the matter gets remanded back to the technical member adjudicate, then it will again get suspended, my lords.
But in the last occasion, on the same point I raised, my lord, there is no judicial member. This case may be heard by this honorable court. That time they raised the objection that it cannot be heard by the honorable
Okay,
court.
I
Remanded
have
back.
considered submissions. I'll go through the judgments and pass orders in chamber.
And also, my lord, one last submission which I'll make. My lord, my learned senior railway councils have always given same submission which I am giving right now against the member technical, and they have been appropriating at the same time reprobating. My lord, they cannot do that. They are
That time my submission was
at some matters, my lord, they are taking this stand that learned RCT technical member can pass the judgment below 2 lakhs, and in some matter they are objecting to it. They are state, my lord, they are bound by Article 14, they cannot do that.
Okay, I'll consider that.
Grateful, my lord.
my lord, last occasion I raised the same point, my lord. That time they had denied.
Chamber. I'll pass orders now in chamber.
Yes, my lord.
You go through the order after some time.
Great.
Yes.